Tomorrow, the trial of Joshua Komazarjevsky is expected to begin in New Haven. He is the second man accused in the home invasion, tortures, and murders of Jennifer Hawk Pettit and her daughters Haley and Michaela. Our next guest is here to talk about what this next trial might look like. Steve Milikowski is an attorney with the Glastonbury firm of Collins, Deans, and Milikowski. Steve, thanks for being here.
Thanks for having me.
So the number one question that we get on the website and just in person with a lot of people is how similar is this trial going to be to that brutal trial that we already have seen and witnessed?
I expect it to be very similar because, one, we have the same judge, and we have the same prosecutors, and we basically have the same set of facts. Mm-hmm. The only difference is that we have a different defendant in this case. But I would expect that the evidence will be very similar. Obviously, it was good enough to get a conviction in the first case. And I don't see the prosecution team straying far from that evidence. They have very solid evidence, obviously. They have a lot of it. And I don't see any reason that things would be different.
Will it be faster? Because a lot of people think, well, the first guy already got convicted, so, I mean, isn't it kind of a foregone conclusion? Or?
No, people need to understand that this is a completely separate trial. Although it's very similar, this is an entirely new jury with an entirely new defendant. So the jury just takes this, from scratch, and every piece of evidence has to be introduced from scratch. And the prosecution can't refer to what happened in the prior trial. Everything's done in the beginning, from the beginning as it was in the first trial. So they can't say, all right, this guy was already convicted, because the truth is Mr. Hayes was convicted by a different jury than the co-defendant, Mr. Komazarjevsky, will be facing.
You talked about it being a different jury, but the other question we always get is, well, I mean, how everybody knows about this. I mean, everybody around the world knows about this case. So how difficult was it, do you think, for them to find a jury? What sorts of things were the standards for them getting people on the jury?
I think it's impossible to find any juror who hasn't heard about this case. I mean, I would worry about the person who's on a jury who hasn't heard about this. Where is that person living under a rock, obviously? But the key is, when you're looking for a jury, you're looking for someone who can, set aside their preconceived notions about everything they've heard through the media and then start the trial with an open mind. And I think that's what the prosecution was looking for and the defense was looking for as well.
One thing that was interesting was, I know that the defense had recently asked for the jury to be sequestered, and the judge said that can't happen because we didn't tell them that they might be sequestered when they were chosen. I mean, is that surprising to you?
I was a little surprised, and that came out in the Current this morning. And the reason I was surprised by that is because it's a potentially appealable issue, and I think that the prosecution in the court is going to look to avoid any appealable issues. Obviously, all that would do is just drag out any potential sentencing, especially a death penalty, years and years and years. So there would be no harm other than, obviously, to the jurors themselves and the inconvenience of that to be sequestered. But certainly, if they were sequestered, there could be no claim that, all right, there was some juror who heard something on the news that influenced them. And obviously, the jurors would be instructed not to talk about it while the case is pending, but of course there'd be some claim that, this juror talked to someone from the media or heard something, and it's a potential problem.
Are you surprised that it is the same judge? It's Judge John Blue. I mean, obviously it was a long, exhausting trial before, and he's going to...
I don't know too many judges who would want to sit through two trials, but I got to think that the defense counsel obviously would raise that as an issue, because here's a judge who's heard the evidence, and they would argue that he's been prejudiced and he's not beginning the trial with an open mind as the jurors are supposed to.
That's interesting. Something else that recently came out, Elaine Griffin did a article about the defense attorneys and the toll that kind of it has taken on their business, that they've, lost clients, that they're, losing business because they're associated with this horrible crime.
As I understand, I think that during the jury selection, they had to make a motion to the court that jury selection only be 4 days a week instead of 5, so they can spend that Friday every week tending to the rest of their business. Otherwise, as they put it, they wouldn't have a business to return to. So, being in court, even just for 1 day, is exhausting. When you come back, you got emails, you got phone calls. These guys, their entire focus is on this one case. So imagine if you're a client of theirs. Are you going to want them as your attorney?
Yeah.
Where's their focus going to be?
Well, let's talk about also being a defense attorney and choosing clients. I mean, is it a difficult thing to do when it is something? I mean, I don't know particularly what kinds of cases that you've been involved in, but I mean, is it difficult when you think perhaps either you think the guy's guilty or you just don't like what they're accused of?
Well, my experience has been that people seem to see that as too black and white. Is he guilty or is he not? I've represented a lot of clients who I believe are guilty, but then there's some circumstances, and I think it's my job to bring that to the court's attention, talk to the prosecutor about it, hopefully get the prosecutor to use his prosecutorial discretion and say, all right, this guy did this, but you know what? let's say, for example, it was a drug case. He was found with drugs, but at the same time, he had some family circumstances. Since then, he's been in treatment. He's working. He's employed. He's doing what he can to kick the habit, and he should be treated differently than some guy who's using drugs, dealing drugs, and has no intention of changing his behavior.
Isn't this second trial, though, really more just about the penalty, what the penalty will be?
I think it is. I think the conviction is a foregone conclusion. I don't see how the defense can get around a conviction in this case. The question is whether or not this is a death penalty case. And I think, quite honestly, if ever there was a death penalty case, this is it. This was premeditated. It was heinous. It was cruel. And, there's no mitigating circumstances that would justify not enforcing the death penalty.
How much do you think, there obviously was a lot of interest worldwide on the first trial. Do you think that will be repeated? I mean, will you be following it as closely?
I think everybody will be following it. How can you not? Maybe since the first trial was the first one to go off, that might have gotten more attention. But certainly this is going to be a trial that will garner worldwide attention.
Are you expecting any surprises that you think might come up? Or?
As far as the trial, I would say no. Again, I think the guilt phase of it is a foregone conclusion. I would expect that as far as the penalty phase, it would be a death penalty case. Unfortunately, and most unfortunately, I think for the victims, the families, is that the process will take years and years and years. So even if the death penalty is enforced, between appeals, which are mandatory, you could be looking at 10, 15, even 20 years. There's people on death row for up to 20 years. And like I said, they're going to find any issue they can to appeal, whether it's sequestering the jury, the case being in New Haven, or whatever they can come up with, they're going to find. And one thing that typically defendants who are found guilty do in these trials is they complain about a lack of effective assistance of counsel. And I guarantee that'll be one of the claims. He'll have a new attorney review it, and God knows what. But it's years down the road, and that's why some victims actually prefer the life sentence as opposed to the death penalty, because the death penalty just drags on for so long.
Right. Interesting. Steve Milikowski, thanks for being here. We appreciate your help on this, and we'll see you throughout the trial. Don't forget, if you missed something on The Real Story, you can now watch it online by going to ctnow.com. You can also catch us on YouTube. And please follow me on Twitter at Lori Perez, WTIC. I will be tweeting from the Komazarjevsky trial starting tomorrow. Thanks for watching this week's edition of The Real Story. We'll see you here again next week.